we haven't agendized this, but you can go ahead and do the, call to order and roll call. And we might as well we can do the pledge too, we can do it twice this evening as well.
Okay.
Whatever we want to do.
Should I read it?
We need
What?
we need Shannon?
We don't need Shannon. The minutes, all the minutes we've put on this.
See, you got retention shit already.
Yeah,
Did you see that?
we-
Okay, this is Thursday, July
Board
19th
members are
at
supposed to be
4 o'clock PM. And this is a special session for the board, NACFD board
It's a workshop.
workshop. Okay, it's a workshop. And let's all stand for the pledge of allegiance.
Hold on a second.
Oh,
Since nobody's here yet.
that is correct.
Okay.
Sorry, guys.
All right, I pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Any roll call?
Where's your calling, sir?
Bailey, sir. And Brian, sir. Okay, Charlotte will start our workshop.
Well, you should have in front of you a notebook. And I've collected a number of items that I think we will find of interest and help, I hope. One of the things that we need to always remind ourselves is that we are here for the taxpayer. And we are a government entity, and that we are largely, unlike a board of private corporation, or even a public corporation, we're primarily governed by statute. So it's important to know, while I know we've talked about, I don't have a draft of bylaws, although I'm well along on them, but I think we need to go through all this too before that, because really what the bylaws a lot of times say is, we will do this according to the Arizona revised statutes. And so we kind of need to know what they are. There's three areas that I believe are the most filled with landmines for lay boards, and that is, one is the scope of your authority and your duties. The second thing is, horrors, the open meeting law. And beyond that, conflicts of interest. So those are the three areas. I also want to know from you tonight, before we get through, I do have on a digital copy of the 2018 AFTA handbook, which we used to call the Red Book. I'm not sure why, but we do. And anyway, it is 233 pages. If you would rather if you want it in hard copy, we'll do that. If you would rather have it on a thumb drive, we'll do that, because it is a PDF file and it's word searchable. So that's one thing you might want to consider when you give me your preference. But we'll get that done. I do have in each of these areas, for example, under your scope of authority and duties, the first general area, I do have Chapter 1 of the AFTA Fire District Handbook, 18th edition, which was done in December 2017. Then open meeting law, I have Chapter 2, and on conflicts of interest, I have Chapter 7 of the AFTA handbook. The other thing that's kind of important, and the reason I've augmented what you have there, is because there are several other things you need to look at. One particular is the statute behind the standard or the premise or the principle, and the other thing would be case law, and the third would be the Attorney General's office opinions, and they have in the past, up until just recently, they have had what they call an agency handbook. But now, under the current administration, I go online and they have taken it off. But I have still given you copies of what I know is current, at least is what I think up until the 2013 handbook. The other thing, I've given you a couple, so you kind of have an idea what they look like, a couple of Attorney General opinions, especially under the open meeting law, because the Attorney General has a, what they call an omelet, which is an open meeting law enforcement team. And so they are very involved in that, although that's not the, it doesn't have to be that way for the Attorney General to make a formal opinion, because under the Attorney General's, what do I want to say, authority, any government, what do we call ourselves, government entity in the state can ask for an opinion of the Attorney General. We can also, the local county attorneys can also give formal opinions when asked. So there's lots of ways to find out whether you're doing it right or not. And so I've added those particular items in here so you can kind of know where they are. And also, and looking at the AFTA handbook, sometimes that is a little brief. You know, they're trying to be brief, even at 233 pages, because it includes finance and a whole bunch of other things in there, including the standards involved in to some extent to emergency medical services and that sort of thing. So I think you'll find, however you get your AFTA handbook, I think you'll find it useful. But again, I think you need to be aware of some other things that we need to do. If you want to take a look at A, which is the Chapter 1 of elected officials' responsibilities. And what AFTA has done here is basically taken the statutes and giving them in simple form. And this is in Title 48. The other thing I should tell you is that Title 48 is a collection of all the special taxing districts in the state. Basically what those are, and the Arizona Constitution treats special taxing districts as municipalities. So you're kind of like a focused municipality. In other words, you don't have to do all the other things that a city or town does, but you are for the purpose of a fire district. There is in the state of in Mojave County, we have, interestingly enough, a combination of city and fire district responsibilities within the city limits, and that is in Bullhead. The Bullhead Fire Department is a special taxing district. It is not a department of the city government. So, but there's also a downside to that, because having been in both city and county government, with the city of Kingman, it was awfully nice for the fire department not to have to deal directly with budget and all of those other things. There's a business department that did that, a finance director that did that, and so there's less, I guess, pressure on the fire administration to be, we'll say political in some of that. So there are some advantages to that sort of thing. On the other hand, fire districts, the special taxing districts, are autonomous. They are responsible directly to the taxpayers. I think you all know that the difference in the city of Kingman and this fire district is the city of Kingman does not depend on property tax. They don't have any property tax. However, fire districts are all dependent on property tax. So in some cities, I'm not sure. I think Bullhead is both, if I'm not mistaken. But there are some cities that have both property tax and because of the way that you can get property tax. There was a certain time in history where the city of Kingman could have had a property tax without having to go to the public vote, but that ended, I think, in 1992, something like that. And so now they have to have in order to actually implement a property tax, they have to go to other people. In any event, so you'll see that there are, by statute, there's particular special duties that are involved, hold public meetings at least once a month. That is a statutory requirement. Okay, submit to County Board of Supervisors a budget estimate. So we have a relationship with the county in terms of budget and finance, in terms of their approving our, for example, our levy rate. So, and that's why we have to go through all those machinations before we pass the budget, to give it to them, to make sure that we have the right levy rate with the right income and the right. And so there's a lot of work that goes on between the administration of the fire department and the county treasurer in determining what all those numbers really are. But anyway, if you look through there, and I don't know if you want to take 5 minutes or so to look through there, there's a few pages here, and just if there's any particular thing you want to discuss.
I have a question on number 5.
Okay.
Fingerprints for state and federal criminal records check. So we have to get fingerprints, but is it the fire department's policy not to hire?
By law, we have to do that. That's,
Okay, but
by.
what if someone comes back with a criminal record? Then what?
That's a good question. I think the obvious answer to that is that we shouldn't hire them. But what is your understanding, Mr. Chief?
My understanding, as long as it's not a conviction for something directly impact the fire department, so theft, moral turpitude, stuff like that.
Moral turpitude, how about drugs?
Drug use, stuff like that, so like misdemeanor stuff, you have to be very careful from
As I say, that's a dicey.
when you hire somebody, or when you refuse to hire somebody for past criminal activity.
Okay, and he's right about that. So, in any event, yes, moral turpitude and substance abuse are the two. All right, as you go down, anything else? Yes.
Yeah, the last one, district shall not incur obligations, debts, and so on, if the taxes are not going to support. Obviously, something went wrong in Mojave Ranchos. Was that just a violation of state law, or was there some other factors that excused that? I mean,
You know, I'm not versed enough on that particular, what the facts were in that case. I was around when all that went on, but that would have to be, and that was part of the reason that in that case, that was probably part of the reason, or the reason I understood, is that the board was dissolved. In fact, they all resigned, and then the board of supervisors appointed an administrator. And until that financial situation, the embarrassing financial situation was resolved, in fact, the administrator is now the executive director of AFTA, John Flynn. And he was there for what, a year?
Well, 2 years.
Was it 2 years?
2 years.
Yeah, yeah. And so until that was all resolved, and so he had the job of getting that all straightened out. Nobody was in that incident, if that's your question, nobody was indicted on that or went to jail because of it, but it was a violation of state statute, and the fix they got themselves into was, I think, considered a lapse of judgment and good administration.
Well, they have some statutes in there that accept as provided by, so obviously there's some ways you can get yourself into trouble.
Right.
And I just focus on
There's
making
lots
sure
of,
we
there's
stay out
lots
of
of ways you
trouble.
can get yourself in trouble, yeah. Lots. Anyway, on the second page, these are this fire district may. These are the first page is what the fire district must do, and the second page is what they may do, permissive. I think number 9, we all know that we are in contract and have retained a certified public accountant to perform annual audits, and that's this Saunders and Company, and they specialize in public accounting, which is very different from private corporate accounting, and they specialize in, they have a lot of fire districts. a audit, so they know what they're doing. Now, just because it says that you can do, doesn't mean that you should. Sandwiched in there, on page 5 of the AFTA article, it talks about the separate legal entities and exercise of joint exercise of powers. We call those intergovernmental agreements, IGAs. And that tells you how those need to be done.
How does that separate itself from mutual aid?
Well, we do mutual aid through an IGA, and same with automatic aid. We do dispatch, the hydrant contract. The dispatch was recently done with so we have a county agency or a county, what do you call it? Anyway, through the city of Kingman, so there's a bunch of fire districts that had to engage in that process. And the IGAs are always approved by, they have to be brought before you for approval through a resolution, and they have to be approved as to form by competent council, like me, yeah. And it's interesting because they talk down here on mergers and consolidations. We had a debate about this a few years ago when we were talking about Mojave Ranchos, maybe consolidating or merging. And I kept saying you have to have an election to do that. And other powers were saying, no, you don't. And I notice in here, 2 or more districts may merge or consolidate. The Board of Supervisors will order an election to merge or consolidate. With an appropriate resolution for merger is submitted to the Board of Supervisors. So that now has been settled. I know, and that, Mr. Berg just pointed out that that was not done in the case of Valley Vista. You know, it's kind of funny, Valley Vista or Truxton or Chloride, and that was under a different administration, and that, I guess if nobody complains, you get away with it.
So the statute was the same back then as it is now?
Absolutely, yes. And I can't explain why that happened, but it did. Okay, it did. Okay, fire districts, and this is, we're formed under Title 48. So on page 6 of 221 of the AFTA book, districts with population of fewer than 4,000 inhabitants, the district may consist of 3 or 5 members. If you're over that, you have to be 5. Yes.
Well, if they require an election to merge and it wasn't held, what's the requirement to separate again?
Well, that's a good question. I think it would somehow have a statute of limitations with, after it's done, it's done. And like I say, I think I've heard particularly lawyers in the public sector at times say, well, who's going to sue? And sometimes things get by when you don't have somebody object. So that's what happened there, and I have a feeling now that it would just simply not be fair to those that participated in that to leave them homeless again. And in the case of Valley Vista, of course, they had well, so did Truxton, and Truxton had a fire department, and Florida did. In fact, one of those, Florida or Truxton, was the oldest in the state. Florida was the oldest fire district in the state. 1914. So I doubt very much that anybody would, it wouldn't be a Kingman Airport Authority situation. It would be, by no means. And of course here, down further, all right, Title 48 is specifically about fire districts. Let me think of, Title 38 is about, which you'll see some other stuff when we get to, especially when we get to conflict of interest and that sort of thing, and open meeting law. We will get to Title 38, which is about public officers and employees. And those rules apply to you also. And then in terms of elections, most of the elections provisions are, for the fire districts, are contained within Title 48, and in particular 803 at SEC, in that area. Also, there are certain things in Title 16 which are about elections statewide. Yes?
Under number 6, says they cannot expand the boundaries of the existing certificate of necessity unless authorized under another chapter. Now, before NICFD was getting individual homeowners who were adjacent to the district to sign up for it. And I guess it was a fairly simple process, but it's more difficult if there's a jump of land. Is this a problem?
I think that would be, yeah, Department of Health Services and fire districts that have ambulance services. Otherwise, we don't require.
A CON only applies to ambulances?
Yes, and
Well, transport agencies. So-
transport agencies.
Transport, so the fire department transports, they will have a certificate of necessity with Department of Health Services, right?
Yeah.
Okay, so to expand for fire is not necessary.
Well, the CON is actually, and the CON also is a, if you will, like a utility. It's a yeah. You get the whole thing. It's a, what do you call it? I'm sorry, I can't think of the word, but it's a monopoly. Okay, so there's only one CON for this area.
But that doesn't apply to the fire department expanding
No,
fire services.
no.
Gotcha.
No, it's not like,
Oh,
the
go ahead.
certificate of necessity prevents ambulances for fighting for business.
Right.
So, like River Medical has a CON here, so not another ambulance can't come in. There's nothing that allows them to come in.
And that just what you said, it prevents competition, but for a good reason, apparently. So
I think it's more to prevent lack of service than it is to prevent multiple service.
Okay.
I think it's more.
well, apparently it's the kind of thing that you make an investment, and if you're subjected to somebody else coming in and taking your business, you can't exist. I think that's part of the rationale. You had something to say?
So to answer your question, for a parcel to come in or a group of parcels to come in, it requires 51% of the residents in that area to sign and 51% of the assessed value. So of one parcel, one owner, that meets that criteria. So if they're on the boundaries, they can just, like you just bringing them in, you can do that.
But that has nothing to do with the CON.
Yeah, I understand. I know that they apply to that.
And you'll see down on 8 that finance provisions are under Chapter 5 of the AFTA book, which you haven't got yet, but you will have when you get your copy. Also, you are responsible for fire code approval. Which fire code are you going to operate under? Which one are we operating under now? I'm sorry, I didn't.
I have the books in my office.
Okay, it's the Uniform Fire Code for a certain year. I don't know which one it is. I didn't check that out.
But it says we can make modifications to that, so are we bound
Yes.
to enforce the state fire code, and then we can add to that, or?
Well, it's the
is it-
uniform fire code, and of course, anything that's under the state fire marshal would also be in addition to that, is that right?
And we also have resolutions like holes in walls or stuff we've added in, so if there's holes in your walls, we can make them repair them because they allow access for the fire into the building, into the structural components. So that's one thing that by resolution that we require them to do.
We can do that either at the time we adopt the uniform code and say that these are additional amendments to what we're adopting, or we can do it item by item. But if I remember the last time I was here, that when they adopted a new version of the uniform code, there was quite a bit, there was a committee that went about you can determine which ones you're not going to adopt, which portions of provisions you're not going to adopt, and then you can also say, okay, instead this is how we're going to operate, and you can put your own rules attached to that, so.
And we try and run parallel with the county too. If they're running off, the Uniform Building Code of 2015, we try and run parallel for the fire code of 2015. That's one thing that we've always tried to run parallel with them on.
I think we try to kind of, are you sensitive, have you been sensitive to what other fire districts or fire departments are doing? Okay.
I think years ago, NACFD actually went with the same building code the city was using.
Okay. So that you can do that too. And you can use their, their additions and subtractions from the uniform code too. You can amend it how you wish before you adopt it, so. An annual audit, again, 12 on page 7, there's a chapter again, 5, in fire district financing, that you'll find information about what's required in the audits. And we've been using the Saunders operation since 2000, I believe, 4. And so they know us pretty well.
So our next thing is going to be strategic planning, policy review, and adoption of the fifth set of bylaws.
Well, again, I'm not going exactly by the, because I didn't get that done. Let's talk about that in a minute. Who did what? Anyway, I have not gotten everything I want to, or the draft down the way I want it. What I'd like to propose is after tonight that, and I know a couple of you have expressed interest in working on that, so what I'll do is get out a draft as soon as I can, I think sometime next week, and get that out to you as soon as I can, and then you can decide whether you want to wait till the next regular meeting, or if you want to have a special meeting to actually go over and in the meantime, I'm going to invite you to make comments, and I certainly can incorporate your comments without endangering the public process.
For these specific words, strategic planning, out of the code, where there's something in the state statute that says would be included in that, or the policy review?
The strategic planning, you can probably answer that too. Usually, for example, you're going to consider tonight, I think we're going to be looking at the process toward your replacement of capital assets. So, and what that schedule is. That's the kind of strategic planning you're talking about. What else do we?
Yeah, short-term, long-term, so when you talk about strategic planning, you're talking about
But
like
if,
5 years, like a 5-year plan, like a 10-year plan, you're talking about this is what we plan on doing in the next 5 years.
but this says we should be doing it.
Yes.
And I have not seen that.
Chief, don't usually do that around budget time in terms of the budget committee and that sort of thing?
We do have strategic.
Because I don't think it's mandated through state statute that you should.
No, it's a should kind of thing,
Okay,
correct.
okay.
I'm sorry, I didn't.
That's usually something the fire chief and his administration will actually work out also, and then they just make us aware of what they're doing.
Okay.
more just a timeline for like replacing equipment and stuff like that, too. We don't keep track of that. The fire chief does.
Okay. All right, and I also have, passed the yellow page.
Can I say something?
Go ahead, yes.
So we're using Uniform Fire Code 2012, International Fire Code 2012.
Is that the latest version?
I believe that's the same one the state fire marshal uses.
They don't do it very often.
Is that the state fire marshal, do they change very often?
It's actually not updated very often either.
Oh, okay.
There's tons and tons and tons of stuff in there.
Well, I know we also used to use, especially for training and qualifications and all that stuff, the NFP.
Different standards for different years.
They do it every year.
Well, they change different stuff every 3 or 4 years, so it's
Okay.
always,
So that's, you know, if you wanted to go by that, one time that was a big thing, if you wanted to go by that, you could also instruct your people, or study that possibility and instruct your management to look into that. I have down here ARS 48803, which is the, and H, I, and J, which are about the statutory requirement of, I guess in short, doing 6 hours training at one of the 2 biannual AFTA conferences. And that is in addition to anything we do. In my thinking, and I think that it says that you have 1 year to do it from the time you become a board member, but it also says that under J, that prior trainings don't count. So I'm thinking if, I'm thinking about that when you are reelected or come back and be elected, that you should do it then. So those that are reelected the year after, they have a year to go to the AFTA conference. Beyond that, I think it is strongly recommended. Number one, just for the professional community and communion, that's important. And
They just recommended that you go every year so you can like get the newest updates, but it is required in the first 12 months that you're elected,
Right.
even if you're reelected. Every time you're elected, you have to go.
right, or appointed. In this case, the last one was July in Phoenix. Nobody seemed real anxious to go down there in July, down in Phoenix in July. But the next one is in January at Laughlin, which is been real popular with locals. So
And
that's
there's also just the possibility if these 2 actually go down or are reelected in November, they would do it in July, then have to turn around and redo it again in January or July again,
okay.
because they'd just be reelected.
That's okay. Okay. I need that clarification. So that's your understanding. That was my understanding too. But okay. And I haven't been to one in years, but way back when I used to go every year, and it was I thought always very, 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 very good. And you hear the nice thing about it is you get updated on things. I would also recommend that we do every time we have an election or an appointment or annually, that we have this kind of a session for our own benefit, and that way then in that particular, this kind of setting, we can ask more questions and I can share my ignorance. But anyway, and also I think you ought to know on section I that AFTA reports who's attended to the boards of supervisors all over the state. And that's how the board of supervisors has determined recently that a board member has complied. So one of the things you gotta do is make sure that, that when you attend, you make yourself known. And number one, you not only check in, go to lunch and all that good stuff, but every seminar, they want you to write your name down. So be sure that you do that. And then also, I recommend that you actually attend the seminar and not go down and drink and gamble. So that would be nice. Okay, let's go on to B. Which are the immunity statutes. And you'll notice here that you are immune from a lawsuit individually, okay, if you perform your duties within the scope and in good faith. So it's really important to understand the scope of your duties. And written opinions of the city or town council or the district council are very handy for you to avoid personal liability. In other words, you don't look real good if, yeah, go ahead.
Well, this just talks about within the course and scope of employment or authority, so I take that applies to all employees, the firemen themselves?
Yes, it does. That's exactly right. And you will find times when it is very convincing, and I've had a couple occasions to, when a board member went direct to an employee and demanded that something be done, I intervened and said, employee, if you don't, this is a no-no. And this, number one, what was required of you doing was something that needed to be decided by the full board. And you don't go and decide that you're gonna carry out a policy that the board has not considered and reviewed and approved as a body.
And who's the Department of Administration under that section?
That would be under the governor's office.
Gotcha.
And actually, that is I'm sorry. In terms of state employees, it would be under the governor's office. But in this case, it is you that have to, we have to approve insurance, liability insurance every year. And a policy, and keep that in force. And that is what you get insured against that. In other words, somebody brings a lawsuit against the board and all the members individually. Well, you're safe, because what the liability insurer does is provide a defense to that particular thing. However, if you've acted often in order to get into an individual's pocket, the plaintiff will say, so-and-so and so-and-so acted outside the scope of their authority as a board member, and therefore are individually liable. So that's what that insurance and your conduct saves against, is your being exposed personally. And you'll notice in B, in 3817, again, it says, notwithstanding any other law, a member of the board is immune from civil liability and is not subject to suit directly or by way of contribution for any act or omission resulting in any damage or injury if the member was acting in good faith and within the scope of the member's official capacity. So in 38446, you can get an opinion from the AG, from the county attorney, or your own attorney about what it is you want to do. You're safe if the attorney says, yeah, you can do it this way. The attorney is in hot water if he or she is not right. However, under 717, you can always guarantee that you're going to be, your personal assets are protected if you're acting in good faith and within the scope of the member's official capacity. We're going to talk about official capacity. Well, you'll see that in the book. Number one, I think under just general law, you're talking about board members. You do not micromanage. They are not super chiefs, and they are not super battalion chiefs. And in fact, when we get into the conflict of interest, you can't. An employee can't be a board member. There is that will be in our bylaws, there is a chain of command. And it is you to him, and him to his next in line. So that's within the scope.
You also can't have a board member with a a relative, it's actually a department of Roseville, correct?
That, yeah, we'll get into that, there's actual statutes about that, yeah, and that gets into the second or third degree of affinity or consanguinity and all that good stuff, but yes, you cannot do that, that's correct. Okay, now we'll go behind C and we get to open meeting law. The first item, I have lots of items here. But I really like the first one, which is called Open Meeting Law 101. It was done under the Ombudsman's Office of the State Legislature. And it was done in 2010, but nothing has changed that doesn't make that, puts it out of date. It is, what, 2 or 3, oh, it's more than that. It's 4 pages long. And it puts everything in a outline form that's easy to understand. And you'll notice down here what constitutes a meeting. A meeting is a gathering in person or through technical devices of a quorum of the public body in which they discuss, propose, or take legal action, including deliberations. This includes telephone and email communications. We'll get back into that a little bit later. I have the H's. Okay, go ahead. You don't need my permission. Go ahead. Right. Anyway, and anybody, what's a quorum in your case?
3.
3, correct. And so a meeting, a quorum is not a couple of you guys standing around talking. That is not a meeting.
Also, when that happened recently with the 2 board members being removed by the courts, Mike and I actually were not talking because we thought 2 of us getting together, out of 3 of us being on the board still were actually a violation, but we found out
This
it's
is
not.
notwithstanding vacancies.
Right.
All right, so you're still, even when there are vacancies, there's a 5-member
Right.
board and 3 are a quorum.
Right.
And when you're talking about a particular item in the, we'll go through that again. But let's talk about how can we screw that up? Probably you have a conversation. How do you turn that into a violation of the open meeting law? You can't.
Okay. Like after Mike and I discussed business, then I called Carl and discussed the same stuff with him.
Yes, and it's called splintering the quorum.
Mm-hmm.
And it's the same thing with you emailing Mike
Right.
and Mike forwarding
Mm-hmm.
or whatever. Now, there's some exceptions to that. Obviously, let's look at it again, and I like the way they've put this together. A meeting is a gathering, in person or through technical devices, of a quorum of a public body at which they discuss, propose, or take legal action, including deliberations. So we're talking about discussing legal action, or that sort of thing. Let's talk about a case in which you say, and you email all of the board members, and you say, I want a special meeting on this date. Is that a violation of the open meeting law? No. No. Setting up meetings, that sort of thing. Are you available? Or, okay, you email, say Mike emails a couple other guys and says, I want this on the next agenda. Is that a violation of open meeting law? No, it's not.
If he says I want this on the agenda and I'm gonna vote no, and they start discussing it, then it is.
That's, yeah, exactly.
There has been kind of disclaimers in the newspaper by the city council where they say, more than a quorum of the council may be at this event. For instance, the lighting of the sign downtown. And that seemed a little bit over the top to me, since that we're not having a meeting. That might be at the same location.
That has been done, to my knowledge, since I was city attorney back in the day. Because number one, it's called CYA. There's not only violations, but there are appearances. We're not only talking about, and attorneys are very well, in terms of ethical breaches. We don't want even to have the appearance of doing it. I remember back in 1992, when I was city attorney, I remember the city mayor and a couple other guys on the council would go over to the timeout after council meetings, and I'd say, guys, and they would say, we're the city council, we can do anything we want to. Well, anyway, nobody ever objected, but when you go to like the after conference, we will do a public notice that you are all gonna be at that conference, and that no legal decision will be made during that time.
We actually also do it for the Christmas party, in case.
Yeah.
board
Yes.
members
Yeah,
show.
party or any event relating to the fire district where we might be there, and
Right.
that's all gonna be done.
Yes.
No, great,
Yes.
okay.
And it doesn't necessarily mean you might not say, you know, what do you think of that thing that happened last week in the, you know, on that particular fire or whatever. That doesn't mean you don't do that, or that you don't discuss issues that you deal with all the time, like at the after conference. But we do notice that, to tell them that in terms of business conducted on behalf of the fire district is not gonna be done there. We're not gonna take any actions, we're not gonna do any of that. So yes, we do that, and that's to avoid, number one, well, it's to give notice and to avoid the appearance of any violation. And let's go back to the two core concepts is behind all this. One, and we're talking here, that at the first, right out of the bat, meetings, okay? That is what it is. And then they put the other one, it is the public policy of the state that meetings of public bodies be, this is in Title 38 also, be conducted openly, and that notices and agendas be provided for such meetings which contain such information as is reasonably necessary to inform the public of the matters to be discussed or decided. And the whole thing, it goes back to the old days of the smoky rooms, decisions being made behind closed doors in smoky rooms. And, we don't do that. We don't allow smoking. All right. Then they go into what is required, open meeting law, notice, agenda, the public's rights, and down here on page 2, it says public rights. The public has a right to attend, to listen, to tape, to videotape. The public has no right to speak or disrupt. Now, I have I believe the current call to the public provision in the open meeting law was put into effect, I believe, in 2000, I better not say, but anyway, before 1999, I know it wasn't in effect, because there's a 1999 Attorney General's opinion that talks about that no, they don't have, the public does not have a right, automatic right to participate. They have a right to listen, to see what's going on, that's transparency. But whenever they did the, and I think it's, I'm putting it in here somewhere, the call to the public, yes, if you go back behind the yellow page, behind this one thing is 43101. And I'm sorry I didn't put in there the date it was amended and put into effect or enacted. But the public may make public body may make an open call to the public during a public meeting, subject to reasonable time, place, and manner restrictions, to allow individuals to address the public body on any issue within the jurisdiction of the public body. I don't know if you've been to the Board of Supervisors, but meeting recently, but several times Chairman Watson has said, but that's not within our jurisdiction. So they get a lot of people complaining. Then at the conclusion, to allow, at the conclusion of an open call to the public, and I've recently upgraded our statement on our agendas to reflect this. At the conclusion of the open call to the public, individual members of the public body may respond to criticism made by those who have addressed the public body, may ask staff to review a matter, or may ask that the matter be put on a future agenda. However, members of the public body shall not discuss or take legal action on matters raised during an open call to the public unless the matters are properly noticed for discussion and legal action. In your case currently now, because of a request of a citizen, a resident of this district, oh gosh, that's several years ago, the open call to the public was put at the last instead of at the first. So now everything's done, and actually, you know, we kind of thought that's kind of silly, but now I kind of appreciate it because you've gotten your business all done, there's nothing further to do, and so it is to prevent this debate, this back and forth, this whatever, and to maintain decorum of the meeting. Any questions about that? And I think Mike asked me a meeting ago whether or not he could ask a question of one of the people in the audience, and I said no. So that's the reason, is we don't have that back and forth, so on and so forth.
Is there any restrictions when it says public? Does that have to be someone who's in,
No, there's no restriction, they don't have to be residents.
That would have to actually be specified in our bylaws, wouldn't it?
Yes, I think you could, that would be, I think, maybe deemed a reasonable restriction. Right now, the restrictions you have is, one of the things we've been doing just by matter of course, and you may want to put in your bylaws, is we've been only doing the open call to the public at regular meetings. Special meetings being that they're for a specific purpose, and we want to get going, and you guys have other things to do than attend board meetings all the time, so we haven't been putting them on that. But in terms of restricting it to residents, I think that's kind of iffy. That's up to you, but I think that, for example, your employees are not all residents of the, and they should be able to be part of the public. All right, any questions so far? Or anything you see in the materials so far that you want to ask a question about? Or just share wisdom? All right. Let's look at this, and then also look at E, which is 51 pages of the Arizona Attorney General's agency handbook. And if you look at, let's go back down to the sections on executive sessions, which starts with section 7-9, which is, let me see what page that is. No, 7.9, sorry. Okay, starts at, actually, oh, that's the after, I'm going to the, now I'm going to page 9.
You're on,
All right, and it's also on page 11 of the after part, which is the,
are you on E or are you in the different one?
okay, I'm on D and E. D is on page 11 and going forward to 12. And then on the
Okay.
AG things, it starts at page 17, I believe. But in any event, if you going back to D, page 12, it lists the different reasons that you can have executive sessions. The most used and abused one is 3, which is 38-431-03A3. Discussion or consultation for legal advice with attorney or attorneys of the public body. I believe the active book does not mention this, but I believe the AG's one does at some point. There's a Supreme Court case called City of Prescott versus somebody that
There's some responsibility somewhere.
your bylaws are very basically, and actually most bylaws or policies make the chairman ultimately responsible for making sure the agenda gets noticed and all that stuff. But that is usually delegated to either the chief and or the attorney.
So you're in the loop on any kind of?
Yes, I have been, and I was before, and I am perfectly happy to be so now. Also, I've been currently, because we have somebody new in the office, although she reviews them, I've been doing the minutes. But I don't intend to do this forever. Just to help out. Okay. On H, we start with the conflict of interest of officers and employees. And again, I've given you this is titled Chapter 7 out of the AFSA handbook. Give you an opportunity to just kind of peruse through that, kind of. Especially, I think the definitions, I think are especially good, because they're stated right on statute. Proprietary interest, either direct or indirect, other than a remote interest. And of course, just before then, they've given you all the remote interests. So if you don't find it there, that's a red flag. And interestingly enough, I had an inquiry from the AG's office on, and I just saw that right now, another political subdivision on the relation of a board member to another agency, and whether that was disclosed. And I think that the thing was that somebody had complained that that was a conflict of interest.
Not good.
Yeah.
Charlotte, we have some big landowners, and I don't think any of this is in this district, but would a substantial tax load as a percentage of the district or area in the district constitute a substantial interest if they were even voting? I mean, it would seem to me that it takes, if you've got a whole city and everybody who votes for the city council, it doesn't matter, but if somebody owns half the town.
You know what? That's a question to which I don't know the answer, or maybe
Parker's
maybe
an
there's.
example.
Well, okay, okay, yeah, that could be. You know what, well, and also I think maybe at one time Lake Havasu could have been in, yeah.
Where?
Lake Havasu could have been.
Yeah, absolutely, sure, in the early days.
Coming
yeah.
down. You know what, I haven't had that come, you know,
Was that like one person actually voting for like hundreds of properties?
yeah,
Yeah.
right.
Actually, the city did that. They were actually thinking about taking in Long Mountain, that whole development,
Oh, yes,
and they were actually gonna do it, initially with one guy owning all those properties after it was subdivided, because that one guy had however many hundreds of lots were out there, he spoke for all those lots. And they were actually thinking about taking property all the way out to Long Mountain, because he actually on his own could actually bring that whole area into the city. It never happened.
to make it
That was,
contiguous.
that was actually a possibility.
So that's, yeah. Well, and like, there is in the statute we were talking about, when you want to merge or consolidate, those statutes also say that that you can avoid an election by the consent of someone who owns a certain percentage, I want to say 31% of the property in the district.
So it may be substantial, but it's legal because it's a
Yes,
separate section.
yeah,
Okay.
because of, yeah,
Gotcha.
so. And you'll notice in 503, 838, 503, there's conflict of interest, and that talks about the employment, the employment of a board member, or the board member being related to any public officer who has or whose relative has a substantial interest in any decision of the public agency shall make known such interest in the official records of the public agency and shall refrain from participating in any manner. So when you have a substantial interest, which is any pecuniary or proprietary interest, in something that the board is going to vote on, you say, I have this interest, you disclose it, and then you refrain, when you do that, when you abstain because of a conflict, and I'll have to go back and find exactly where that is, but when you abstain, it is like you're not there. So if you're a quorum, and a mere quorum, and one of you has a conflict of interest and must abstain, it's like you're not there, so you don't have a quorum anymore. So you can't vote on it. That's kind of an interesting one.
You can't abstain just because you don't want to like take part in it.
Right, you can't abstain just to ruin the quorum, you have to, it has to be for a.
That happened recently also.
Yeah. So that's, anyway, we're almost to the end here, we could probably go have a hamburger.
Charlotte, what about not attending? Now, we have had members attend via telephone. Can they, are we authorized to use proxies if we're not gonna be in town?
No, that is not authorized. But telephonic, we could even do a video if we had the potential to do that, which I think we do here, but I'm not sure. But yeah, just so that you are the one that has to make the decisions. You're the one that has to hear the debate and the discussion and make a decision, so. And again, I know it is specifically provided for in probably somewhere in these materials, but I don't remember exactly.
When the public wants to look at the minutes, do they just come into the administration office? Do we have them hang in there so they can review them and buy them if they need them?
Yes.
And what's a policy for document charges?
Yes, and the law requires that the minutes be posted 3 working days after the meeting. Now, I will confess, I missed this last Tuesday, I didn't get them done until. But, and also then we do post them on the website.
Okay.
So they're in both places. And if I'm not mistaken, I'm almost sure that what we did years back is I think we recorded something and then gave it to the clerk of the board of supervisors. But we recorded when we're going to meet, the time for our regular meetings, the monthly meeting, and where we're going to post both our agendas and our minutes. And so we've been doing a posting here, and now if we want to take them around to some of the other stations, we can do that. But we felt like that as long as we're posting them on the website, then posting them here in the main office is sufficient. There has been a time when the website was down, and AFTA gave us the counsel that we could post them on AFTA website if we wanted to, and then increase the number of places that we physically posted the hard copy.
Do we charge the public for copies at this time, or?
No, I'd like you to consider, we used to at the city, and I think they do the same thing at Board of Supervisors. We used to have copies available copies of the agenda
Right.
available. And I think that would be a good idea, so that they know what's there. Copies of the minutes, if they want copies, they can download them off the website. They're downloadable, the PDF format. And same with the agenda, we post the agenda on the website. Okay, any more questions? Oh, I also included, because I think they're a lot easier to you may feel they're easier to follow than the active book, but there's the statutes, 38503 through on conflict of interest. So, and I think it's kind of interesting, which we haven't been doing, 38509 says that the disclosures should be filed with a public agency. That may be something you want to consider requiring. Of disclosures of